Вітаємо, пане Тарасе.
Welcome, Taras, at the second stage of selection to the High Qualification Commission of Judges, at the interview stage. The selection commission is holding this interview in the following purposes: Robert Brookhuizen, me, Ivan Mishenko, Sergei Verlanov, Robert Brookhuizen, Zhachny, and Steven Markman. Yevhen Mezentsev is not participating in the selection because he has announced self-recusal. The rapporteurs for your interview are me and Robert Brookhuizen. If for some reason our interview is interrupted, Taras, we will definitely continue with it at some other date and some other time, and we will definitely communicate with you on this. The interview consists of the Q&A session. Please give concise answers, and the commissioner asking you questions can limit the time of your answer. We have structured the interview in the way to give an opportunity to all the candidates right at the beginning to present themselves, to tell about their motivation for applying for the HQCJ. That's why let me invite you to do this. Please, you're welcome. Why have you decided to apply? What ideas have you got on the functioning of the judiciary and the judiciary in general and the HQCJ and whatever else you want to inform us? Thank you, dear members of the Commission. First of all, let me mention that I'm very happy to participate in this selection process because me and a lot of other people in my country for a third year in a row have been waiting for this competition to take place, and finally it is taking place, so their feeling is rather positive. I feel pleased about that, and I'm also a little bit worried because it was not so often that in my life I had to look for a job, to apply for a position, and quite a long period for quite a long period of my life I was involved in selection procedures. It all started when I became a partner of the law firm, and for 15 years I worked within the law business, which I quit in 2012. And then I started dealing with selection of lawyers, because a good team of a law firm is one of the preconditions of the success of this law firm. The HR context got wider for me when I moved to the alternative dispute resolution field, and when I started working with the Court of Arbitration affiliated with the Chamber of Commerce, International Chamber of Commerce, and then the one of Ukraine. I faced new challenges, new procedures, like development of the lists of judges of courts of arbitration. The process has been going on all the time since then, and I have to be involved in it all the time. And of course, when COVID and war started, the process was suspended. We are not changing lists of judges of courts of arbitration now. And I was also involved in the development of the staff of the judiciary when I was elected to the Public Integrity Council, and also when I was doing analytical work of a senior analyst within international technical support projects for the judiciary. Here I mean selections to the High Anti-Corruption Court, High Court of Intellectual Property. And over the recent 3 years, I've been involved several times in the staff HR commissions of the prosecutor's office when there was the process of attestation of prosecutors going on. I've also got some interesting experience of being involved in the judiciary. And let me tell you right away that this is caused by my ardent desire, after I got a lot of experience in the law, to see significant changes in the judiciary. I want to see those changes, and I saw that there are just a few chances to introduce those changes. I think that the years 2012, 2013 are the years of the greatest degree of dependence of the judiciary. And I wanted to create alternative reality in non-state courts. That's why I started dealing with development of courts of arbitration. And if I have a chance to tell more later about this experience, I would rather tell you a couple of words on that. Also, I've got some experience of being partially involved in the development of legislative acts, and I mentioned this in my motivation letter. And I worked with three major directions. These are alternative dispute resolution, judicial reform, and since I had been dealing with investment disputes, I supported them in courts, so both state courts and non-public courts. So I also focused on the aspects of the reform of commercial courts that have to be introduced. In particular, I studied the mechanism of the work of mixed panel of judges involving judges delegated by business, the way this is happening in many European countries. I did a study, and since autumn, I've started writing my scientific paper because I became a postgraduate student of the Institute of State and Law of the National Academy of Sciences. I can see that I have not mentioned anything about my vision, and time is almost over. But I hope that you will ask me questions, and I will have a chance to disclose this information. I don't think that the questions are going to be easy, but I will try to answer them. Thank you for your attention. Thank you. So let's start. Have you watched the interviews? Well, sure. That is the object of my professional interest. So whenever I've had some free time, instead of watching movies, I was watching interviews. But did you somehow prepare for the interview? I've already mentioned that we have been waiting for this selection process for 3 years, so I cannot tell that I've been preparing for 3 years, but of course I have prepared myself. I've looked through my publications and articles, some of my publications made by my colleagues, to the extent I had time. Okay, Taras, just now and in your motivation letter, you mentioned courts of arbitration. You explained that you were involved in the establishment and reform of that system of courts of arbitration. There is an opinion that courts of arbitration and the very idea is not something that is rather common for the Ukrainian system. And there have been some controversial situations related to courts of arbitration when courts of arbitration passed some strange decisions that were further subject to appeal. Here is my first question. Do you agree with this assessment or not? I mean, do you agree that courts of arbitration are not yet very much common for the judiciary of Ukraine? And if you agree, then yes. Then why? Well, I do not agree with this idea as for now, because I had the pleasure and the honor of being in charge of the analytical project on the development of Court of Arbitrations for 7 months. And by the way, this was happening within the project which I'm now showing you. This is the report of that on that project. So we had a sociological survey that was related for the first time to the activity of courts of arbitration. And partially, thanks to my work I had been doing since 2011, we can say that the level of trust in courts of arbitration as of 2018 was already a bit higher, but still higher than in general courts. The awareness raising the awareness of the people who are not lawyers, who are laymen, was about the activity of courts of arbitration was more than 80%. People know that they exist. When I was entering this field of activity, the situation was very bad and the image was very bad. And I actually started working with this area in the background of the conflict. There were two parallel congresses, one of them appealing the decision of the other one. And we had to hold another Congress where I was elected deputy head of the arbitration chamber. And then when I was elected head of that chamber, that was a unanimous decision, and there was no internal conflict between two Congresses of judges. And we have managed to settle a lot of issues. You know, you have to work with negative things, and unfortunately, that's what we lack in terms of increasing the level of trust, public trust in the judiciary. But that's what we focused on for courts of arbitration. The challenges were that courts of arbitration were often accused of raiding. But in the report, we showed how many cases like that we had. And you know, every problem can be settled if you work with negative elements, if you recognize the problem, if you take some action. In 2018, we made some analysis, and since 2014, there have been no high-profile cases that would discredit courts of arbitration. And now the demand, well, not the demand, but the interest in courts of arbitration is increasing. Of course, not during the wartime, but before the war, it was increasing. And this is not in terms of the cases heard, because there is a lot of room for perfection there. But the point is that businesses are now resorting to courts of arbitration more and more. And a lot of agreements contain some arbitration reservations. Okay, let me try to ask you another question. You know, I have faced cases when credit agreements of banks quite often presuppose some activity of courts of arbitration affiliated with bank associations. Maybe that's a coincidence, maybe not, but all the disputes going and resolved under those court reservations, arbitration reservations, and all the disputes that were to be settled by those courts of arbitration, where the cases where decisions were made in favor of banks. And there were only occasional exceptions when decisions were passed in favor of the other party. And the impression actually was, or the impression could actually be, that these courts of arbitration established by banks themselves could be acting in favor or in the interest of banks. And they would be listening more to the bank arguments and not be that scrupulous and attentive about the interests of the borrower. Well, that was the problem, and actually that is still the problem. And there is another project which studies the quality of service, financial services provision, also made a conclusion like this. We cooperate with bank associations in this respect. I oppose their principle. I oppose this arrangement, and now in the Verkhovna Rada there is a draft law which is supposed to reduce the number of courts of arbitration, because we have about 500 of them registered, but only about 100 or 50 of them are functioning. I'm deeply convinced that such disputes should not be considered by courts of arbitration, because normally these are disputes related to charging some small debts. And there is nothing strange about having a decision in favor of the bank, because the family of those cases is rather simple. But they should be better considered by state-owned courts within the fast-track procedure. In particular, if we take into account the fact that state courts can be better transformed in terms of information technologies. Unfortunately, courts of arbitration still have to use simple post, because this is the main aspect of our activity, so no electronic procedures. Thank you. Let's go over to the activity of the HQCJ. And again, in your motivation letter, you mention some discretion of specific members of the commission or discretion of all the members, all the composition. We have been discussing this issue at our interviews many a time, and the former composition of the HQCJ is largely criticized because they had this discretion, a great extent of discretion, and it was not always communicated in the right way. As you think, if we have an ideal HQCJ, what should be the aspect where this discretion can be manifested, and what kind of discretion should it be? In what issues? Because if there is no discretion at all, then why should we have members of the HQCJ at all? Well, thank you for the question. These issues, and in particular the issue I've mentioned, have been studied, and me and some former members of the HQCJ have written a report. This is a small report, but anyway, with some information on this subject. I think that I can tell from my experience that it's not the issue of availability of discretion in any of the scope of that discretion, but it's all about the fact that the decisions of the HQCJ did not explain the scoring system. It was not clear how the points were given to this or that candidate. And I think that discretion of the members of the HQCJ should still be there. There should be some discretion. First of all, the HQCJ should be, the burden of its work should be relieved. I mean that there could be some outsourcing for tracking practical assignments. Well, the only thing that should be left for them is interviews and studying the dossier. The Commission shouldn't have to spend more time for communication than just 1 hour. But what is the scope of discretion in relation or in correlation with the figure which is set for scoring? Well, it's difficult to say. I think that it's the Commission itself that has to settle this issue, but definitely there should be some discretion left. But the doubts concerning the origin of the points and any suspicions that were available and that were actually grounded because the scoring was not explained, well, these things should be removed. The Commission should be open and transparent, and there should be no question about personal voting. We heard some objections from the HQCJ that there are some risks. They are running those risks. But it was not so at that time, and now I think that this cannot be accepted as well, because we have even more risks now. In your motivational letter, you mentioned that I think my professional slogan is my ability to reach a compromise and to settle conflicts. In case you are appointed a member of the HQCJ, whom are you going to have conflicts with? Well, that's a very wide, a very broad field. It's difficult even to describe it. First of all, that will be about the development of the team, of the common vision, common values, and what we should start our work with, because the tasks are really comprehensive, and it's possible to achieve the objectives only if you work together. So I would take pains to develop this system of common values and vision of the Commission. As far as potential conflicts are concerned, let me just focus on the work of the previous HQCJ. I used to be a member of the Public Integrity of Council, and I think that the format of relationship between the HQCJ and the PIC should change. And I see how this can be done, because besides other things, I was also a member of the mediation group within the PIC, and we were making attempts to do mediation as we were suggested by the USA. So we partially took that path, and we were reaching some compromise in some issues. I will not describe this process because there is a certain share of risks in any procedure, and conflicts may arise. It's difficult to predict them, but I'm ready to take pains to settle those conflicts, to resolve those conflicts. And I've got the necessary experience for that. I can tell you about this experience. It's not only about courts of arbitration. I also participated in 2 large-scale mediation projects which have been successfully completed. And I've also got some other experience within such reconciliation and mediation procedures. Thank you, and let me give the floor to my colleague Robert.
Good morning, Mr. Shepel, if I say it correctly, I hope. The first question I have for you is, yesterday, preparing for this interview, I looked at the website of your arbitration institute within the Chamber of Commerce, and I couldn't find you in English. And then I asked one of our assistants to look at it, and he could find you on the Ukrainian website. Please tell me, is being the chairman of this institution a paid position, or are you not paid for this position?
This is the position from the list of staff members, and I'm paid. This is half of the full-time job.
Okay.
Like I get half of the payment.
Okay, so you are employed by the Arbitration Institute. In your documents, you say that you're also acting as an arbitrator. Is that within the same Arbitration Institute?
Yes, within the same institution, I'm the arbitrator, and the only form of work of arbitrators is that we have civil law agreements, and I get royalties from the cases I have heard.
Okay, but isn't that strange that you are employed by the institute itself and that you act as an arbitrator within? Because then you may have a conflict possibly in the appointment, or do I see this incorrectly?
Well, that's the system we have for courts of arbitration in Ukraine. The salary, the minimum salary I get, is the salary I get because I'm holding an administrative position. The salaries are given only to the head chairman of the Court of Arbitration and the secretary. Because we are holding administrative positions, we have to be staying at our workplace, otherwise it would be difficult to arrange all the correspondence of the Court of Arbitration. But when I'm appointed by the parties to hear a case, I perform the functions of the arbitrator in specific hearings.
Okay, so you don't see a conflict there?
Well, that's the way our legislation says. That's what our system is. And the same goes for the international courts of arbitration. So it's not only the Ukrainian system, but the system, the way it works in other countries as well.
Okay, I don't think it works in that way with us. I always say that the main difference between arbitration and regular court is, and I don't know whether it's the position in Ukraine as well, that let's say arbitration people are appointed by the parties. And it's one difference, and the second difference is secrecy. And that in the agreements of arbitration, there is often a clause which says that the parties have an obligation to keep everything that is within the arbitration a secret. Is that also so in your arbitration court?
Yes, you're absolutely right. That works the same way in Ukraine. And let me also mention that the only other difference is that we have international arbitration and internal domestic arbitration.
I saw that. Yes.
I work within domestic ones with the disputes related to the president of Ukraine. I will check why we don't have the English version on the website of the Chamber of Commerce and Industry of Ukraine. Okay. Maybe that's because of that.
Can you imagine that I, as a, let's say, so-called foreign expert, find it very strange that someone who is a, let's say, product of secret dispute resolution is so involved in, let's say, a state-based judiciary and preaches, let's say, transparent and open procedures. I have difficulty to follow that.
Let me try and explain this. We have another peculiarity. We don't have the so-called open lists of arbitrators, which means that every person who is a lawyer cannot be appointed to hear a case. You can just take a person for arbitration from the list. And why I don't see any conflict? Because the functions of the head of the Court of Arbitration are more of administrative nature, and they don't presuppose any interference, any opportunity for interfering into any case considered and heard by other court arbitrators. I would say that that the head, the chairman of this court is often cannot be involved in any case. But of course, if the parties appoint me, I do have to do this, to perform this function in case I don't have any conflict of interest. For me, it's just a natural thing which does not cause any additional questions or I think that, well, to tell the truth, it's the first time I hear this view of the problem, but maybe you also have grounds to think it like that.
Yes, I do, because I'm involved in a few very, very large arbitrations where I have found that the arbitration is used by countries to hide that their activities were corrupt. And that by, let's say, having closed proceedings, they are not forced to show that there's a corruption issue at stake, and the issue is solved without anyone knowing that it exists.
So, if I tell about this from my practice and experience, I can tell that the situation is the opposite. You know, state court judges have guaranteed salaries, but in courts of arbitration, our situation is different. And the requirements concerning integrity are much higher with us. Because
but that's not what I mean. What I mean is that I don't doubt, let's say, the professionalism of the arbitrators which are selected. But what I doubt sometimes is the reason for parties to adhere to arbitration, which often is done when they have something to hide.
well, maybe that's true, and there could be a complaint raised by this, and it has been raised, by the way, in relation to courts of arbitration. These are the so-called artificially staged disputes that aim to transfer property or to settle some internal problems. That's what we can see sometimes. But since I work in the most reputable institution of Ukraine, the Chamber of Commerce and Industry, we are rather scrupulous about every single case, and we don't want to have any negative, notorious reputation, because otherwise people will stop addressing us. That's why the goal of my work was to create an institution of integrity, the space where we could be solving disputes with integrity. And that's why I initiated draft law on the reform of the architecture of courts of arbitration, because I'm also dissatisfied with the situation when about 500 courts are registered, and some of them are known only for one decision, notorious decision, I would say. Maybe they were created, established right for this specific decision because they didn't hear any other case after that. And this draft law in the Verkhovna Rada, it has been passed in the first reading, and I hope that it will be adopted in the nearest future by the parliamentary committee at least.
Okay, thank you. On one other subject, I have one question. That is that I read here that you were the assistant to the People's Deputy of Ukraine, Lukyanov. Can you read it?
Да. Лук'янов Владислав, партія регіонів.
Which I understand is a politician. Is that correct?
Yes. Back then, it was a politician, the MP.
Yeah, I asked that because in your motivation letter you say, I do not belong and did not belong to political parties, trade unions, did not and do not participate in their activities. Is the answer correct?
Well, it is the true answer, the correct answer, and I provided the explanations to the Commission on this point. This question was also raised when I was undergoing selection for the Public Integrity Council. And it's really true that I was not a member of any political party, including the Body of Regions. I didn't have a vote even for this party. And I did not share a lot of the views of this party. I explained how it happened that I was the assistant of the MP on public grounds, which does not presuppose any salary payments. That was about 10 years ago. I don't think that this was a major episode in my biography, because then I was not performing any special functions. And this happened because then I started working in the International Chamber of Commerce, ICC. And
of course, I've read your explanation, of course. The point is that in the question we asked you whether you have participated in political activities. And then you give the answer where you say, I did not belong to political parties, trade unions, did not and do not participate in their activities. So we asked for participation in political activity. As far as I can see it, this was a political activity, wasn't it? And as I see it, and maybe I'm wrong, you didn't answer the question correctly.
Well, I think that political activity is participation in the activities of a certain political party, being candidates for some election from the party. But assistant of an MP has some expert functions. I was providing expert support in very limited scope back then. And, well, I didn't have any occasion even to discuss political views with that candidate or discuss his political agenda. The only draft law in the discussion of which I participated as an expert back then was the new version of the law on financial monitoring. I made some reservations. They were taken into account. Some people were dissatisfied with me as a result of that discussions, and that's why I was not invited any other time to participate in any discussion as the expert. And I don't regard this to be my political activity.
Okay, thank you for your answers. May I please pass the floor to Ted, I guess, huh?
Yep.
Yes, yes, it is still morning here. But good morning, Mr. Shepel. I've been quite anxious, frankly, to have the opportunity to participate in your interview. As you may recall, I had the occasion to be acquainted with your work during the PCIe involvement in the High Anti-Corruption Court. You and Mr. Kozlov have prepared a very, very insightful publication and document on the High Qualification Commission of Judges. It's entitled How the High Qualification Commission of Judges of Ukraine Can Fulfill Its Mission, Analysis of Procedures and Ways to Improve Them. And it is somewhat to my regret, perhaps more to yours, that not sufficient reference has been made to that very important document, in my opinion, by some of the candidates that we have interviewed. But you can be gratified by my observation that a good many of the suggestions that you and Mr. Kozlov have made in this document have actually been not referenced, but nevertheless opinions expressed, shared by a number of the candidates. So there appears to be significant common ground. Now, with that small speech that I have given you, let me deal with some of the suggestions that you and Mr. Kozlov have invited the public and persons interested in the administration of justice by the HQCJ, some of the suggestions that you have made. The overall impression that I get from your analysis and your recommendations for improvement is the increased almost mechanization of the process of the HQCJ. It is very clear that one of the concerns that you have expressed is the lack of transparency of the past work of the HQCJ, because some of the criteria upon which they evaluate candidates have not been publicly announced and applied in an obvious way. The contention is made that there is too much discretion that the members of the HQCJ have. You and virtually every other candidate has shared with us their knowledge, their experience in the law, their education, and persuaded us that all of that will be of important contribution as members of HQCJ. Is there not a contradiction between that and your theory or proposition that the amount of discretion and personal contribution of HQCJ members should be reduced?
Well, I don't see any special controversy here. Maybe there was some exaggeration about the role of mechanization and automation of this process in your perception. I think that automation should just reduce some physical share of work, even some intellectual work load, like checking practical assignments, because quite often the commission had to be closed for several weeks just to check all practical assignments. So that's not what should be there. I actually support the idea that members of the HQCJ should have a share of discretion. And I don't actually think that some neural networks or AI can replace judges and can replace members of the HQCJ, because we have morale, dignity, honesty, ethics, and these are human things, and humans are to judge. And there are some aspects that only can be decided by humans. So a number of functions related to this are the functions of the HQCJ members, because they are professional, reputable lawyers who are the bearers of certain morale. What are the limits of discretion? While writing this publication, I did not determine this, because that should not be just an opinion of mine. I can make a suggestion, but I don't know what kind of commission we will have, what the values of the commission are going to be, that it confesses what people are included there and what compromise is reached. I think that there must be some reasonable balance that will enable the members of the HQCJ to apply their experience to use the level of their morale, integrity, honesty, perception of objective reality. But on the other hand, this should correspond to the limited time and resources they will have. I have already mentioned that physical contact and communication with the members of the HQCJ with the candidates cannot last long. That's why they should rely on other procedures like testing of psychological skills and clarification of the issues related to the competence of the judicial candidates. I hope very much that I have answered at least partially your complex question. If I've got something wrong, please try to clarify your question, and maybe I will try to provide a better explanation.
Well, there's no right and wrong in this discussion. There are options and opinions. However, let me move on. I'm turning now to the conclusions in your paper, and among other conclusions, you of course correctly observe that there is a huge workload that needs to be faced by the HQCJ. And we've heard much about that from many candidates. Everybody knows what the numbers are. But you go on to make the following conclusion. That is to say, how the problem of the huge workload can be addressed. The problem can be solved through wide involvement of experts in evaluating judges and judicial candidates and staff in general on a number of critical indicators and the public to collect information. Now, the wide involvement of experts in evaluating judges and judicial candidates, that is the core responsibility of the members of the HQCJ. Why would you propose that be outsourced to what you call experts in evaluating judges and judicial candidates? Isn't that the expertise that we expect from the HQCJ members?
The point is that in some directions, the expert involved can be more qualified, better qualified than members of the HQCJ. I mean, only some aspects. That's the way we could deal with if we involve some scientists and academicians in the development of practical assignments, and we could also involve some technical staff to arrange remote online testing. So that's what I mean. There have been a lot of complaints concerning the procedure of performance of practical assignments and their checking. I've given you several reasons why I don't think that this is a normal, good situation, because different members of the HQCJ have different experience and different level, different approach to assessment of the tasks. And sometimes one collegium, one panel of the HQCJ may have a different impression of the practical assignment performance and of the candidate. Then the other panel would have a different approach. But during the procedure, we didn't have the clear criteria, clear reasoning why this or that number of points was given to that candidate. That's why I think that practical assignments and their examination, their checking, should be given to academicians who are even more competent in this process. And the same refers to moral and psychological skills. Well, we could mention the polygraph here, but it's a controversial issue. So to sum up, I would say that we could outsource only the aspects where the experts involved can work better than the members of the HQCJ, only.
All right, I understand better now. Thank you. Let me turn to another aspect of your report, and it deals basically with the criteria and approach to the assessment of integrity and professional competence, which of course, again, is at the core of the responsibility of the HQCJ. But to have common criteria, you suggest should involve meetings between the PIC, and perhaps even civil society organizations that, of course, elect the PIC, and the membership of the HQCJ. I was involved in doing a conciliation between the HQCJ and the civil society organizations, and what became very clear to me is that there was a difference of opinion that was held with respect to the criteria of integrity and professional competence and the application of those. Your document suggests that there be, and I would suggest to implement your idea, that there be a committee established in order to attempt to agree on the criteria for integrity and professional competence so that the same criteria are used by all of the important people involved in the process. I would suggest a third party be added to that committee, and it be the High Council of Justice, because all of those three parties are involved in the selection process for judges and, of course, their transfer to higher courts. What do you think of that idea? And as a member of HQCJ, would you participate in such a committee?
Well, it's an absolutely good, relevant idea, and I also think that the High Council of Justice cannot be standing aside the processes because they actually supervise the decisions of the HQCJ, and this is all about the principle of predictability for every candidate. Candidates, judicial candidates and judges should know what the criteria are for their assessment. The future HQCJ will have a better starting point than the previous HQCJ for several reasons. First of all, we have the hope that the future HQCJ will have not just judges on the board who show this corporate unity, but the representatives of civil society who will also have some critical vote there. The future PIC will start not from scratch, but on the basis of the analytical work that has been performed by the previous composition. It seems to me that all judges have been analyzed. There are analytical materials on all of them. Also, some approaches, some practice have been already developed. So I think that at this organizational first stage, we should not start working until we predetermine common unified criteria and standards and approaches, and until we set the identifiers for all the criteria. And they have to be approved together by the PIC, the HQCJ, and the High Council of Justice. This is really important for the candidates, judicial candidates. They should be applying when they already realize what the criteria are. They need to understand that, for example, following the criteria of the previous HQCJ, they could be eligible, and according to the new criteria, they are not, so they would not apply.
Thank you for your answer, and let me thank you for the contribution that you have made to the study of the operation of the HQCJ and some very, I think, important and insightful suggestions you have for changes. I'm going to turn you over to my colleague, Judge Markman, who will now have some questions for you as well.
Thank you, Mr. Shepel, for being here this morning and participating in our competition. In one significant respect, I agree with what my colleague, Judge Zarzeczny, just said concerning outsourcing. My anticipation or expectation, if we placed you on the High Council, would be that you would be exercising your judgment and your discretion and making the important decisions about the future of the judiciary, and not outsourcing these to others or to experts or to persons who we've not selected. Is that a fair expectation on my part? I understand there may be some areas in which there's minimal discretion in which outsourcing would be important, but I would hope that Mr. Shepel would be making the important and the hard decisions if he were placed on the HQJC. Is that a correct expectation?
Well, thank you for your statement and for the question. It's really true, and I agree with you here. But just, I have some minor reservation for this statement. The HQCJ is a joint collegial body, and I hope very much that other members of the commission will be motivated, in case I'm appointed, motivated to select the best judges. And I hope that they will not tolerate any negative phenomena like somebody's requests and somebody's interference. Then we could accept this challenge and undertake this responsibility, and your expectation would be absolutely right, because we will really have to use our own discretion, our own vision of the values, and bring these values into the judicial community, which probably lacks them to a certain extent, and give an opportunity to the best judges to have career growth and self-fulfillment. Because I know that in the judiciary we do have judges who have a very poor, a weak vote, and they are afraid even to tell about some things honestly. But we should provide them with such an opportunity.
Mr. Shepel, in my experience in the United States, alternative dispute resolution, such as arbitration, is largely dependent upon the perception of lawyers about the strength of the judicial system. The stronger the judicial system is perceived, the less need there is to rely upon alternative dispute resolution. My first question is that a similar understanding to what we have in Ukraine? And secondly, if it is, my understanding is the more you do as a member of the High Qualifications Commission to strengthen the judiciary of Ukraine, the more you would be weakening the institution of arbitration. Is that correct?
Well, you know, I've got the answer to your question since I've been contemplating a lot on this topic. I really supported the same idea. I also thought that the state system of courts is a competitor to courts of arbitration. But then the criticism and lack of perception of the judiciary, the state judiciary, as a reliable system of dispute resolution, in particular by businesses, when this reached the peak point, I saw that there is an opportunity for creating this kind of club of like-minded people. The people who want to rescue themselves from this situation and who want to find some alternative reality. And then, unfortunately, I came to realize that alternative dispute resolution, in particular internal arbitration, will not be developing because they don't have any prospects of development if the situation is generally bad in the judiciary as such, in the state judiciary. I changed my mind. Recently, I've had some negotiations with the representatives of businesses. This was a frank discussion, frank negotiation, and I actually asked them to take those arbitration reservations. And I started thinking whether, well, I was asked some questions, and I said that the only guarantee I can give you is that your opponents will not have any advantages. And my interlocutor told me, I'll be brief, just a moment. Thank you.
So to the extent there's any tension between the judicial system and arbitration, if you were placed upon the High Qualifications Commission, you would give every priority and every emphasis to your work in strengthening the Ukrainian judiciary, to the extent that there's attention. Maybe there's not as much of attention as some people feel, but that would be your first priority, would it not be?
The judiciary of Ukraine will be a priority for me, because if it is really strengthened, that will provide additional prospects for the development of Court of Arbitration as alternative court dispute resolution, because now they are not competing for the reason I have mentioned. Unfortunately, the judiciary is provides some predictability, while courts of arbitration are not predictable. Both systems should become unpredictable, and then there will be prospects for development of both of them.
Thank you, Mr. Shepel. During the life of this commission, the selection commission, and during the interview processes, we've heard a lot of criticisms of the Ukrainian judiciary. We've heard a lot about the weaknesses of the Ukrainian judiciary. And I like the fact that in your motivation letter, you say there are also strengths to this judiciary. And we haven't heard too much about those. And I think it's an important sense of balance that you bring to bear in the process. Can you just very briefly share what you see are some of the strengths of the judiciary in Ukraine that we don't want to upset by any process of reform of the High Qualifications Commission?
Well, everything is in fact very simple. I think that a strong point is, for example, establishment of the Supreme Court. Well, there are different assessments of the Supreme Court, but I think it's a progress, it's a success story. Also, High Anti-Corruption Court of Ukraine, but unfortunately the transformations in the judiciary stopped at that point. After that, no more success stories. But the point is that when the new Supreme Court was established, well, you know, I have not been dealing with any cases as a lawyer, as a representative for 10 years, and I cannot actually be making my own judgment. But I have to use some feedback of the third parties, of lawyers, attorneys at law, business representatives. And what I have heard was that establishment of the new Supreme Court led to reduction of corruption, because the Supreme Court became unpredictable. Before 2016, we used to have the situation that you could find a person, a lawyer, an attorney at law who could guarantee that I will settle your case along the whole vertical line. But starting with 2017, that has no longer been the case. And this, of course, undermines those corruption principles of trial and appellate courts. Why pay there if there is no guarantee that the highest court institution will also grant the case on the basis of bribes? So that's what I feel, and I think that this is the path we should be moving along to the future. And I also help very much that this concept of mixed composition of judicial panels for commercial disputes in state courts following the German model will be implemented soon, because that is a fast-track mechanism, and I have done my best to ensure this, and this will not require any extra effort. I think that if I become a member of the HQCJ, I will just have to take a minor effort to ensure implementation of those developments.
Well, thank you for bringing some sense of balance to our considerations. Let me ask you this finally. This is an issue that Judge Mishenko briefly discussed at the outset of the interview. You said your biggest challenge would be dealing with people who shared much different values in terms of what the HQJC should be doing. And you specifically said the biggest challenge would be dealing with those, and I quote you, who pursue not the goal they have declared. I can't imagine that there would be any who would not be concerned about a commissioner on the HQJC who would not be pursuing the goals that each of them has declared. We've made no decisions as of yet. How do we avoid placing or recommending to the High Council of Justice those people who will not abide by the goal they have declared? Before it's too late, how do we identify in advance of our decisions those who will not adhere to their commitments and goals? Or is it simply an impossible thing to do very well?
Well, this is the most difficult issue. The most difficult question is for me. I'm still an alien observer in this process because I'm a candidate. I'm not on the commission, but I have watched a number of interviews and I saw the list and I know some people from the list of candidates. And I mean, give you some hope, because on this list, I really see very good candidates. And I can already think it over how they could form a majority in the future HQCJ. I, as a candidate, have some conflict of interest. I will not call you and I will not give you any names, not to disqualify the whole process, right? I will not speak on the candidates because
Please don't
we
mention
have
specifics.
to continue with the HCJ. And I see that the commission is doing well. It's a pleasure for me to see that the interviews, starting with the first to the last one, are not changing their structure and all the candidates are in equal conditions. Well, of course, I have the advantage because I could watch the previous interviews. The first candidates didn't have this chance. But I'm optimistic about the results. And I'm sure that your values and your experience are sufficient to distinguish between people and to find the people who are not pursuing the goal they have declared. But I'm not in your place, in your shoes. It's difficult for me to advise anything.
I understand it's a difficult question, but you've raised the issue, and I thought it was insightful to even raise the issue. So thank you, and thank you for your response to my questions. And we'll move to my colleague, Judge Verlanov.
Thank you, Stephen.
Good afternoon, Taras. So let me continue with the questions. My question is as follows. In view of your experience working with PIC and the Jure Foundation that you have founded, so what are the most useful skills that you would apply should you be appointed as member of HQCJ? Thank you for this question. If we are talking about some skills that could become handy, it's important how I present myself. I do have this vast experience of working with civil society organizations. I'm a founder and board member of one of those organizations. But the greatest achievement of me working with that civil society organization was to work within a team, work with analysts, summarizing their work, and writing specific decisions and recommendations. I would not call myself a leading civil activist. My involvement with the Jure was quite episodic. The board is entrusted with electing an executive director, so practically I was not involved in the operational activities of the organization. I had this vast experience between 2014 and 2016 working with an expert group on the judiciary reform, but it wasn't any kind of formal situation, any type of formal work. So I have established a certain kind of relationship with civil society organizations, And this could be my positive contribution to building a partnership as a member of HQCJ with those civil society organizations, and not just one of them, but a number of civil society organizations that I'm familiar with, and they know me quite well. Thank you. My next question is as follows. What were some of the issues that you've seen in the interaction between PIC as a member of PIC and the previous composition of HQCJ during their joint work? We had both issues and also opportunities to reach some compromise. So it wasn't all negative. But one of the most serious issues that I can name is that the two bodies have not reached any joint list of the indicators of integrity since the very beginning of their work. So initially, they did not agree on how they will be assessing this criteria. And the PCIe, having a wider mandate than PIC, managed to find this solution. But again, we are talking about the mandate and capacities. And I think this is where we have to start. And as was previously mentioned by Ted, and I agree with that, I think that HCJ should also be involved in this process because they finalized the work of HQCJ, and they should be following the same standards and approaches. Even if PIC and HQCJ find those common standards, but they are different from those used by HCJ, we may find ourselves in a situation when judges selected by HQCJ will not be appointed by HCJ. So these practically have to be the first steps in the common activities of HCJ, PIC, and HCJ. Yes. Maybe not the first step, but the third or fourth step, because the first step would be to form the vision on how a new HQCJ is going to work to organize the internal procedures. I would also mention the work with information technologies. It's very important that these things are done before that. So we should spend more time on some organizational issues at first, and then we will be ready to get up with the speed. Thank you, Taras. I'm now passing the floor to our chair, Mr. Ivan Mishchenko. Do we have any additional questions for the candidate? There are none. Taras, your interview is coming to an end. Could you please summarize it for us? What is it that you'd like to tell the commissioners at the very end? Thank you for this opportunity. During the interview, we have not discussed a very important aspect, which is prospects and the future. I'm modestly optimistic about the future, but I've been witnessing some positive dynamics in the changes of the judiciary, which somehow is not reflected in the level of trust in the judiciary. And I heard you asking this question as to why the level of trust is quite low. So if I may, I would like to comment on that. The dynamics of changes sometimes does not meet the public expectations. And in the future, we may have this situation when after the end of the war, some active people will come back from the front lines, the others will return from the European countries, where they have seen a different reality, different level of legal culture, and public expectations will be even higher. Maybe that's even for the better. And even the best HQCJ and the best HCJ may not meet those high public expectations. In particular, as we are approaching the new elections, and dissatisfaction may be used by some political forces to reach their specific goals. That's why I would like to wish your selection commission and the future HQCJ and HCJ for all of us together to put as much effort into having these positive changes meet the expectations of the public. Otherwise, we may be finding ourselves under the greatest pressure. And should I be selected as a member of HQCJ, I'm not sure whether I would feel happy about that, or maybe I would feel the burden of responsibility and the importance of those tasks lying ahead. So I want for all of us to meet the level of those expectations, and may God help us. Thank you.
Дякуємо, пане Тарасе.
Thank you, Taras.
Особисто завершено.
This is the end of your
Дякуємо вам
interview.
за неї.
Thank you for participation.
Всього вам найкращого. Бережіть себе.
All best to you. Take care and goodbye. Thank you. Goodbye.